We asked Chris Syder, a partner at DAC Beechcroft, for his opinion on a recent story we covered. We reported recently a story on Network Rail using commuting distance to the office as a selection criterion when deciding who to make redundant during a relocation exercise. They were relocating their headquarters from London to Milton Keynes. Chris, is that legal?
Aha. Good question. Well phrased. What the lawyer would want to know is, first of all, what are the contractual terms for these affected employees with regard to their place of work and or the mobility clauses within their contracts. Working on the basis that they don't have mobility, you're looking at a classic place of work redundancy situation, because obviously Network Rail wants to shut down and relocate to Milton Keynes. In circumstances where you have that place of work and redundancy situation, the focus tends to be on redeployment. I would expect Network Rail in those circumstances to be trying to job match. Okay, so from what have we got here, what do we need in the new entity, who moves across? Okay, it may well have a scenario where it could have, as a result, a competitive selection scenario. It has more candidates than it needs for the roles, and that's where they would need to start considering criteria. And that's where the novel suggestion is that they're going to be applying, possibly as the principal criterion or as part of the selection criteria, the use of travel distance. And the unions have already kicked up a fuss about this with regards to the fact that they feel it's rather arbitrary and rather unfair. And you can see their point, especially when, as I understand it, you have a scenario where middle and senior management won't be subject to a 75-minute commute limit. They'll have a 90-minute commute limit. So it does beg the question, why? It then begs the question for the lawyer, has there been an impact assessment? Who does this affect? Are we going to face discrimination issues here? And secondly, more importantly, how flexible is this policy going to be? What happens if you've got an individual who wants the job in Milton Keynes, who's prepared to commute, but it takes them 85 minutes? They're prepared to do the journey because they need the job. Will Network Rail turn them down? So whilst it's perfectly legal to consider a range of criteria, what I suggest Network Rail need to be considering is the risks associated with using that criterion, the risks of employee relations issues that's going to cause within the workforce, especially with the especially with regard to the trade unions, and therefore they need to be assessing the risk that this is going to result in a rather difficult public relations exercise, but also potentially a number of tribunal claims if it transpires that there are 10, 20, 50, 100 people who unfortunately made redundant, principally because of this criterion.